So we'll start now. My name is Catherine Wilhelm. I'm the Executive Director at the US Asia Law Institute at NYU School of Law. Welcome to our special program, Trends in the Innocence Movement in Asia and the United States. We have attendees from across Asia and the United States, as well as a few in Australia, Europe, and South America. So this demonstrates that innocence work has a very clear international dimension. Of course, each country's criminal procedures are very different, but we've found that there are many similarities with respect to the causes of wrongful convictions and also the challenges to preventing and redressing them. Our institute began in 2015 to explore the international dimensions of exoneration work. And since then, we have facilitated many workshops and expert exchanges involving the organizations that are participating in our panel discussions today. And by the way, again, for those of you who maybe came in a little late, the names and stories of these organizations can be found in the e-brochure that is on our website. So bringing these organizations together today is a kind of reunion of old friends. We decided to make the program open to the public so that we could expand the circle of the conversation and enable more Americans to know about the terrific work that their fellow lawyers and activists are doing in Asia. So our goals for tonight, as for all of our wrongful convictions programs, are to learn from each other and to inspire each other. And perhaps we can also consider future collaborations in advocating for an internationally recognized right to post-conviction relief based on actual innocence. Now we are truly honored to open with a special speaker, Peter Neufeld, who is known to many of you as the co-founder and special counsel of the Innocence Project in New York. Peter is a nationally recognized civil rights lawyer who has spent more than 35 years trying cases on behalf of victims of police misconduct and wrongful convictions. So Peter, over to you at this point.
All right, Catherine, thank you very much. And special thanks to the US Asia Law Institute for setting up this program. And frankly, particularly grateful to all of our East Asian friends who are getting up early in the morning to join us in this program. It's a lot easier here in New York where it's 7:30 in the evening. You know, and I expect this evening you're going to hear lots of remarks in a very positive context about the trends that have occurred in the innocence movement, particularly in the last couple of years. But I think, you know, before you hear from everybody, I think we need to put it in some kind of not historical, but contemporary context. And I was thinking about the fact that there is an institute called the World Justice Project, which evaluates each country's compliance with the rule of law. And if we look at that trend over the last several years, there are more countries in decline than there are in compliance. And that's a very, very bad trend. The other thing is that when we look at the different countries and how they're doing in criminal justice and human rights, that one cannot make generalizations about entire continents, or for that matter, even East Asia, that there is tremendous disparity between the rule of law in some countries in Asia and other countries, just as there is between some countries in Western Europe and other countries. And even within a country, our US speakers can fill you in on the reality that the United States criminal legal systems vary from state to state. There is great concern in some and not such great concern in others, and even within a state from county to county. It depends on who's in power. So that's one factor to consider. And of course, the other factor over the last year is the role of the COVID-19 pandemic. There's no question from data around the world that the greatest toll is on those same populations who traditionally are excluded from fair and just legal systems. And that in turn makes it increasingly difficult for those populations to have their legal and civil rights protected during the pandemic. Those people, of course, are the ones from uncertain migration, have uncertain migration status, come from some kind of informal economies or poor, those who are racially, ethnically, religiously discriminated against, or otherwise marginally discriminated against. And it's against this kind of backdrop of the rule of law and the pandemic that we're here today to talk about positive trends in the Innocence movement. And that's a good thing. Two of the subjects that we'll be discussing today are prosecutors and junk science. When I think of prosecutors, I can't help but to think about, in this country, the Christian Bible and a reference in that Bible to their God, which says that the Lord giveth and the Lord taketh away. Blessed is the name of the Lord. Basically teaching its followers that humans are to accept with humility and faith the directions they receive from God. And we will discuss today how prosecutors have been delegated godlike power in the US criminal legal systems for centuries, where they literally giveth and taketh away. There will be discussion about how that power has been terribly abused for centuries, particularly against those same marginalized and vulnerable populations, and how that abuse leads to wrongful convictions. On the other hand, we'll be talking about how they can giveth, how more recently, there is a subset of more progressive prosecutors reflected in a modest but growing movement, particularly in large urban cities, who are trying to rein in some of those historical abuses and use their unequaled power to mitigate some of those systemic unfairnesses that we're all familiar with, and how they do it to reinvestigate certain alleged wrongful convictions and remediate them at times. And we will also be discussing junk science. And in that sense, we're all in it together. I mean, why is it that Taiwan, Japan, China, and the United States, all of our governments are terribly concerned about the accuracy and reliability of clinical devices used to diagnose health conditions, but we care so little for the forensic methods and devices that law enforcement uses to ultimately decide questions of liberty and life itself. And in that regard, perhaps all of our nations are alike, because all of us care about our health, but very few of us, and that is, there's a very small constituency that cares about these forensic methods that are used on people accused of crime. It's a terrible double standard, and people in the Innocence movement worldwide are attempting to address that double standard. And you'll hear about their efforts, you'll hear about their successes. I'm thrilled that you're all here. I'm thrilled that you all care. I hope you find the program meaningful.
Peter, thank you so much. That really summed up the message of the evening and got us off to a terrific start. So our next speaker is Meredith Kennedy. She is the director of the Innocence Project's Innocence Network. The network has nearly 70 member organizations, including 13 outside the United States. Meredith's unit provides these organizations with various kinds of support. And every year she has been a good friend to our institute by welcoming us when we come visiting with delegations from various Asian exoneration organizations, as well as judges and prosecutors from Asia. And we visit the Innocence Project to exchange experiences just as we are tonight and learn from each other. So thank you for joining us tonight, Meredith, and the floor is yours.
Thank you so much, Catherine, and thank you so much to the whole US Asia Law Institute for organizing this session this evening, inviting me and some of my colleagues from the Innocence Project to participate. So as Catherine said, my name is Meredith Kennedy. I am the director of the department at the Innocence Project that helps to coordinate the work of the Innocence Network. And the Innocence Network is a coalition, an international coalition of 68 independent innocence organizations, all working collaboratively and in concert to help free innocent people who have been wrongfully convicted and support those individuals after they are free. So I'm just going to talk for a few minutes at the start of the program tonight and share with you some more information about the Innocence Network and a bit about our work over the last couple of years. And I do just want to highlight the Innocence Network members that are participating in the session this evening. Taiwan Innocence Project, which is an organization that has been part of our network for the last 6 years or so. We're going to be hearing from them. We're also going to be hearing from the Boston College Innocence Program, which is a newer member of the Innocence Network located here in the US. And then, of course, from Innocence Project Japan, who we hope soon will become a member of the Innocence Network. So just a little bit of background about what the network is. It has been around since 2005. My department at the Innocence Project was established to support the network in 2012. So the network outdates my department. It was around a lot longer. There are currently 68 organizations that are part of the network, as Catherine said. 56 of those are in the US, 13 are outside of the US. So though we are still primarily a domestic network, a US-based network, the trajectory of growth that we are seeing in terms of our international members is very rapid. So that is definitely the fastest growing sector of our memberships, organizations from outside of the US. Most of the organizations that make up the Innocence Network are rather small, have an average staff of 5 people and an average budget size of $275,000. And a lot of different kinds of innocence organizations are part of the network. Some are nonprofit organizations or non-governmental organizations. Some are clinics within law schools at universities. Some are units of public defender offices. And then we have some organizations that are hybrids of some of these different structures. So it is definitely a diverse coalition in terms of the types of organizations that make up the network. As I said, majority of our organizations are located inside of the US. I have this map here, which shows you where our members are located. You see many, many blue dots inside of the United States, but we're very happy and proud of our 13 organizations located outside of the United States. And of course, you can see the blue dot on Taiwan. So as I said, innocence organizations that are part of the network are structured in a variety of different ways. Everyone is independent, meaning they are responsible for raising their own money to fund their work. They are responsible for deciding what cases they will take on. They are responsible for determining their own litigation strategy. And everyone uses their own branding. So this slide just shows some of the different logos and names of organizations that are part of the Innocence Network. Some highlights of our work over the last couple of years that I wanted to share with all of you. And this first bullet is something we are all very, very proud of. We collectively, as independent organizations, achieved 67 unique exonerations in calendar year 2019. We're about to update this slide for 2020 as soon as this year is over, but in 2019, we achieved 67 exonerations. That was up from 60 in 2018, 53 in 2017. So you can see this number, historically increases every year. And the 67 we achieved in 2019 was the highest number ever in a single calendar year. We also are building capacity collectively in the network. Our combined aggregate budget in 2019 was almost $54 million. And that represents an increase of 20% over 2018 and the highest year-over-year increase since my department began tracking that budgetary information in 2013. We're also raising a lot more money collectively. Not every organization in the network fundraises, But for those who do, we collectively raised about $47.5 million in 2019. Again, an increase of 11% over 2018. And as our capacity grows, the demand for our help is growing as well. So in 2019, we had just over 22,000 people who wrote to us, wrote to our members for the first time to ask for assistance. And that is up from almost 18,000 unique individuals in 2018. So a very significant growth in terms of the number of people we're hearing from year to year. I also just wanted to briefly, since I'm sure we have some folks who are participating in the program tonight who are not yet involved with the Innocence Network, share some ways that you can get involved with the Innocence Network if you would like. The first is a big day that we host every year where we focus on causes and remedies of wrongful convictions, and that is Wrongful Conviction Day. So this is held every year on October 2nd, so just recently happened. But it is a day of awareness and education involving everybody in the Innocence Network and many, many, many people outside of the Innocence Network. We do a lot of activities online, so a lot of digital engagement with folks around wrongful convictions. Last year, it was fully online, obviously, because of the pandemic. We held a 12-hour-long live stream with 12 hours of content produced by Innocence Network members around wrongful convictions. So I invite all of you to participate on October 2nd, 2021 in Wrongful Conviction Day. And on the next slide here, I have our dedicated Wrongful Conviction Day website URL. It's wrongfulconvictionday.org, very easy to remember. And I've also included here some screenshots of public service announcements that were recorded for us in honor of Wrongful Conviction Day by some of our partners at the NBA, coaches and players at the NBA. And then finally, the Innocence Network Conference. I know some of you have attended the Innocence Network Conference. Again, because of the pandemic, we weren't able to hold the conference in 2020. We're not going to be able to hold the conference in 2021, but 2022, we will be back in April in Phoenix with this incredible gathering of folks from all over the world who are involved in innocence work. And I absolutely invite you to visit our website for more information about the organizations that make up the network, the conference, Wrongful Conviction Day, and please don't hesitate to reach out to us if you are working at an innocence organization and you're interested in potentially being part of the Innocence Network or part of a regional network that might be in your part of the world. Please reach out to us because we would love to help make those kinds of connections.
Meredith, thank you so much. There was so much good news in that presentation. It really lifts the spirits. And so everybody keep in mind, mark in your calendars, April 2022, Phoenix. So now we're going to begin the first of our two discussion panels. Let me just explain that we're going to have the two panels back to back, and then we'll take questions for all of the panelists in a single Q&A session afterward. And the way to submit your questions will be to type it into the Q&A panel. Please distinguish between the Q&A and the chat panels. We won't be looking for questions in the chat panel. So at any point, you can feel free to start entering questions in the Q&A panel. And also, I anticipate there are going to be more questions than time. So I would encourage audience to submit their questions, and also panelists to directly engage with the audience in the question panel. So if there are answers that are not complicated, not long, type your answers directly in to everybody in the group. And that way we can have more, kind of simultaneous tracks of exchange at the same time. So the panels are going to be moderated by Ira Belkin, who is our Executive Director Emeritus. He's still with us as a senior research scholar, and he's a former federal prosecutor. So Ira, I hand the baton to you.
Thanks, Catherine, and welcome everyone. I'm just going to say very few words about the panel, how we decided to organize it this way. as Catherine mentioned, our groups of speakers and organizations really have become friends over the last couple of years. And we met a few weeks ago just to update each other on our work. And we found that of all the topics that people are working on, these two topics had the most. Different organizations had something to say about their work in the last year or so. So that's how we chose these topics. And the first one is on junk science. And I'm just going to do a very brief introduction of each panelist before they speak. But there's more information on their bio and their organizations, as Catherine said, in our brochure. I would also say there's not enough time for each speaker to really give their topic justice. But hopefully they'll be whetting your appetite and you'll follow up either directly with them or with us, and we'll get you more information. The first speaker is Chris Fabricant, who many of you know, one of our leading experts on the topic of junk science and an incredibly strategic thinker in how to eliminate junk science, both in individual cases and systemically. And so Chris, I'm going to turn it over to you and start the clock.
Thank you so much, Ira, and thank you to the US Asia Law Institute. I'm always pleased to participate in these incredible international panels. I thought I would talk a little bit, since I only have 8 minutes, right? So when I was hired in 2012 to start the Strategic Litigation Department at the Innocence Project, what the idea behind this was is that we had this body of cases that at the time it was around 300, a little less than 300. And from those cases, each of the factors that had contributed to the wrongful conviction had been teased out. And really what we teased out from these individual cases, what the leading contributing factors were that contributed to DNA exonerations or to wrongful convictions. And so we knew that eyewitness misidentification, the misapplication of forensic sciences, and false confessions were really the three chief contributors to convictions that were proven false by DNA. And so my role was to start this litigation department that worked on some exoneration cases, but also worked on trying to prevent future wrongful convictions. And the idea from that was we were going to get more scientifically valid tests for eyewitness identification evidence, and then we were going to try to root out junk science. And so the first case that I worked on was what's known as a Fry hearing in New York. And that's really there are two types of laws. There's Fry and there's Daubert in the United States. And both are just hearings that discuss that are designed to test the scientific validity and reliability of the forensic method at issue. So the idea is that courts are supposed to act before trial to exclude unreliable evidence to prevent wrongful convictions. That's the idea. The courts have been terrible at excluding junk science, and we know that from wrongful conviction cases. And so probably the worst offender in this arena, are really two. There's microscopic hair comparison evidence and bite marks are probably the worst of these, and shaken baby syndrome, which you'll get from Kana later, have contributed probably as individual forensic disciplines or diagnoses to the most wrongful convictions. And so when we got this murder case and they were trying to introduce bite mark evidence, and this was after publication of the 2009 National Academy of Sciences report that addressed 13 different forensic techniques and found them all lacking in scientific validity and reliability, and certainly not the ability to identify particular suspects to the exclusion of everybody else on the planet. But what was singled out for really a profound critique was bite mark evidence. And so we went into this hearing, and the Innocence Project poured resources into this hearing, and we lost. There had been countless wrongful convictions. The National Academy of Sciences spoken. We had Dr. Karen Cafeter, who's one of the most respected statisticians in the country, testify on our behalf. We had new evidence, and we lost it all. And really what they relied on, the court relied on, not on science at all. The court didn't even consider the science, really. What the court relied on was case law and legal precedent instead of real science. And so what we took away from that was this idea is that, okay, for us to root out junk science, we're not just going to be able to have the best science or the best scientists, but we're going to have to do something about case law, and that we're going to have to address the way that courts are actually considering this evidence. Otherwise, the Innocence Project will never go out of business. We're just going to create more and more clients for ourselves. And our goal really ultimately is to go out of business, to make us obsolete. And so this has been extremely frustrating because courts, to get them to admit that, that the century of case law is wrong is very, very challenging in the United States. And so what we've been doing is we work on wrongful conviction cases, and we work on trying to prove the innocence of these people that were convicted on wrongful conviction. And we've done this in a number of cases without DNA evidence, just by discrediting the forensic technique. And through that work, we've demonstrated that the case law is wrong, that it's false, that all these cases that stand for the proposition that this is science and this is valid and it's reliable and it's good enough to make life and liberty decisions is wrong. And just these last, maybe year, suddenly we're starting to get real decisions coming out of courts that recognize just how destructive the reflexive embrace of legal precedent is as a proxy for scientific validity. And so what our department has been working on have been these cases where courts have denied even having a hearing to test the scientific validity of a particular technique because the case law says that there's no reason to have a hearing, right? This is valid. And we've used the work of the Innocence Project and the wrongful convictions of all of our partners around the country and around the world that are joining us here tonight to point this out. And so we've gotten two decisions, one from the New York's highest court, which is called the New York Court of Appeals, and only a few days ago from the Connecticut Supreme Court, that if you don't know the history behind the use of junk science in the American criminal justice system, wouldn't strike you as groundbreaking. But I'll read a line from this, and I sent this around to a huge listserv of people because it was so groundbreaking that the court of, and this was in a firearms analysis case, or sometimes called ballistics. And what the court had done is denied a hearing and relied on case law exclusively. And this Connecticut Supreme Court, and this is a case where we don't know if somebody is innocent or guilty, said that it was an abuse of discretion not to hold the hearing. It was an abuse of discretion not to consider the findings of the National Academy of Sciences before denying the hearing. It said that science, however, is not static. Methodologies are continually challenged and improved so that an approach once favored by the scientific community may later cede to a novel approach or simply fall out of favor in its entirety. Now that, it's, in and of itself is not a groundbreaking thing to say, but in court, that's an astonishing thing to say. And it's really the work of everybody that is on this panel that has contributed to these courts kind of recognizing the power that case law has had to prevent progress. One of the other things the court said in this Connecticut case, and what's really been one of the real bugaboos about trying to prevent wrongful conviction and root out junk science, is that courts rely on defense attorneys like me to cross-examine expert witnesses to demonstrate the unreliability to the jury. And so they just kick it all to the jury, and scientifically illiterate judges, scientifically illiterate jurors are left to decide what's valid and what's not. And they get it wrong all the time. They just try to decide if the defendant is guilty or not. And this court said that cross-examination could not undo the harm of admitting what was unreliable evidence, or at least theoretically unreliable evidence. And that's also groundbreaking. So for us that are working on rooting out junk science, these type of decisions give us some optimism, I'll call it, even though most of you who know me, I'm very cynical, that judges are starting to get it, that there is a human cost behind the introduction of junk science. And so from my perspective, we're starting to chip away at a century of case law, and that gives me some optimism.
Chris, thank you so much for that introduction and for staying within the time limits. I'm sure many of us would love to hear more about this, and I hope we'll be able to do that on another occasion. And congratulations on those two amazing victories. You're doing amazing work. Our next speaker is an attorney from China, Miss Yutian Miao. She is a lawyer at the Shangtuan law firm in Beijing, which has a pro bono project providing legal aid in wrongful conviction cases. And they've been doing this for about 5 years and had an amazing track record of exonerating innocent people who've been wrongly convicted. We've had several of their lawyers come to NYU, including their managing partner, Mr. Mali Shin. And so we're anxious to hear from Ms. Yu about recent work that the Shangchuan law firm has been doing.
Thank you. Honorable professors, ladies and gentlemen, nice to meet you all. It is a great pleasure for me to attend this online conference and share some of my thoughts about the junk science in jurisdiction. I'm Tina, and you can call me Tina. So today I'm going to talk about some examples of junk science in the unjust cases and share some ideas about how to eliminate the use of junk science. The first point is the process of material extraction, storage, and the procedure of tests do not comply with the law, thus causes the preliminary problem of junk science. There are 3 examples. The first one is about the witness who signed on the on-site report in Liu Xinhua's murder case happened to be the driver of the investigation organ. And another similar case, the expert who writes autopsy report in Zhang Zhichao's case had participated in the interrogate as investigators. So their identities are illegal according to the Chinese law. The third one is about a field inspection record in Liu Xinhua's case. It's been recorded that a place found mud, hair, cement, and extract 2 long hair in the bathroom. The length and color of the hair were not clearly recorded, and obviously no photos or videos were taken. I'll go further to talk about this case later. Here, I just want to mention that the record is too simple. There are more similar cases. I'm going to move on to the next point. The problem of the material source. I'm going to give you more information about the Liu Xinhua's case. First one is forensic medical examination report recorded that the victim had hair length of 26 centimeters long, and the victim's hair was brown-red. In another expertise report, the inspection material is recorded as there are 2 black hairs and 1 brown hair, 4 to 5 centimeters long. The investigation organ issued a statement that the remaining 5 hairs were suspected to be black after being sent to the department for inspection. So we can conclude from the above information that the color and length of the hair did not match the victims. There is inconsistency between the inspection material and the on-site material in the process of transferring the evidence. There's another valuable point in this case. At the very beginning of the investigation, these hairs were sent to several judicial expertise centers, but were filled in the process of tests. About 3 months later, another expertise center gave the clear opinion that the on-site hair matched the victim's DNA. So the different results are really perplexing. The contamination problem is revealed by the different results of these 2 tests. Okay, I'll go to the third point. The scientific method may not be scientific enough. Here are some examples that pose questions about how scientific the scientific report is. The first one is about mtDNA identification method in Liu's case. As I've mentioned, the hair that investigators extracted in Liu Xinhua's house, according to mtDNA report, matches the victims. But according to the principle of forensic medicine, as long as they are maternal relatives, they are the same mtDNA. So mtDNA identification generally can only make excluded identification, cannot make the same identification. According to the forensic experts of the public security, this is another example. It is recorded for the analysis of the cause of death. The blunt instrument and sharp instrument were ruled out first, followed by common poisons, and the cause of death obviously supported mechanical asphyxiation. That is, the expert deduced the conclusion that the victim died of mechanical asphyxiation throughout the method of exclusion. The method of exclusion, however, does not exhaust all the possibilities that and do not consider other exceptions. That is another example. And there are also some examples about scientific insufficient DNA points and false positive in DNA identification. These problems happened in a great number of cases, and it's very easy to understand. So I'm going to move to another example. The problem that the expert may be subjectively interfered by other factors of the case. In the case of Miu Xinhua, it's very easy to understand the expert that made the report have already participated in the interrogate, as I've mentioned before. So the expert may be influenced. So, okay, I'm going to the fourth point. It's about the test opinions. It's sometimes wrongfully analysis and use. I want to talk about the shoe print identification in Xu Jinlong's case. In this case, a shoe print inspection report shows that the sneakers marks left on the scene and the sneakers worn by the suspect Xu Yusen of the same type of number 40 rubber sneakers produced by the same manufacturer. Therefore, the public security believes that Xu Yusen arrived at the scene of the crime. However, it is too bold for making judgment. What should be valued in this case is the detailed characteristics. The shoe print on the spot is reported. Art depression can be seen faintly, but Xu Yusen's shoes are reported. The wear of the whole shoe is more severe than the damage of the impression of the spot shoes, and the inner part of the shoe is cracked. Therefore, the shoe print characteristics of the perpetrators are not consistent with those of Xu Yusen. Okay, I've already shown a great number of cases. I'm going to talk about some ideas to eliminate the use of junk signs. I think we should attach more importance to the investigation and evidence collection procedures of scientific evidence. I think we should put more valuable points on cultivate judges' understanding and prudent attitude towards scientific evidence and strengthen their examination and judgment ability of scientific evidence. Also, I think we should improve the attendance rate for expert and expert witness to appear in court. So in conclusion, it will be helpful to eliminate the junk signs by ensuring the authenticity of the inspection material, ensuring the scientific nature of the test method, ensuring the correctness of the using and reasoning the scientific report. That's all. Thank you.
Thank you. That was an amazing review of so many issues that I'm sure are familiar to many of the folks in our audience, especially folks who work on forensic evidence. And I can't believe you did it all in 8 minutes. But from issues regarding bias of forensic examiners, mistakes in the collection of evidence and in the examination of evidence, I think you sounded a lot of familiar themes. And I'm sure there are folks on the panel and in the audience who are going to want to follow up with you. And again, I just want to congratulate you and the Shangquan for all the amazing work that you're doing, not just in exonerating individuals who've been wrongly convicted, but also improving the criminal justice system in China. We're going to turn next to Japan. Many of you know Kana Sasakura. She holds leading positions in not one, but 2 organizations that exonerate the innocent, the Japan Innocence Project, and also the project that works on shaken baby syndrome. And she's done amazing work. And I'm going to turn it over to Kana to talk about some of the work that the Japan Innocence Project and Shaken Baby Syndrome Project have been doing. Kana?
Thank you so much, Ira, for your kind comments. So hi, everybody. I'm Kana Sasakura, and I'm a professor at Kona University. And I'm a deputy director of the Innocence Project Japan. And Innocence Project Japan was founded in 2016. But a year after, we launched the SBS Review Project, which focuses exclusively on SBS or shaken baby syndrome or abusive head trauma or AHT. And I am the co-director of the SBS review project. Today, my talk is going to be on how we are trying to challenge the science behind SBS or AHT with much help from the international innocence community. So as many of you may know, shaken baby syndrome is a severe form of child abuse caused by violently shaking an infant or child. And SBS was traditionally diagnosed when a baby had 3 symptoms called the triad. So subdural hemorrhage, retinal hemorrhage, and the brain swelling. And we call this the SBS hypothesis. And what we are doing is to question the science or SBS hypothesis. So the hypothesis was born in around 1970s, and there have been many accusations and convictions based on SBS hypothesis in the United States and United Kingdom in the 1990s and after 1990s. But there have been rising criticisms in the Western world since 1980s or and on. And there have been many exonerations and acquittals thanks to the innocence organizations around the world. But in Japan, what we were doing was the Japanese doctors imported the SBS hypothesis in the early 1990s. And SBS hypothesis was becoming popular in the United States and United Kingdom in the 1980s and 1990s. And coinciding with the fight against child abuse in Japan in the 2000s, SBS hypothesis and its believers, mostly they were pediatricians, they gained popularity by the late 2000s in Japan. So in the Western world, there were many exonerations happening in the late 2000s, but we didn't know that situation until after 2015 or so. So the result was that there were many accusations based on doctors' diagnosis of abuse, especially after 2010 in Japan. So SBS diagnoses were mainly made based on the triad of symptoms. But some neurosurgeons in Japan were concerned about this situation because they knew from experience that shortfalls and other mechanisms can cause the triad and not the shaking alone. But they did not speak up. And there was no one who translated or introduced numerous articles or literature in the United States or United Kingdom or in Europe questioning and challenging the SBS hypothesis. So I got together with an attorney from Osaka, Mr. Masashi Akita, in 2017. And we exchanged email messages about the SBS case he was working on. But he didn't know about the situation, all the challenges that were happening towards the SBS or AHD hypothesis in the Western world. So, and we knew that this situation was becoming very serious because there were many people who were who may have been wrongfully accused or convicted in Japan. So we launched the SBS review project in September of 2017. And we now currently have about 30 members, lawyers and scholars. So what we do, just briefly going through what we do. So research and translation, we have gathered so far around 700 English articles and books and over 300 Japanese articles and books. And also we are trying to work on translating these key English articles and court decisions challenging SBS hypothesis that were written in English. And we gather information every day through the Innocence Network's SBS listserv. And we also educate the public. We have held international symposium, 2 international symposiums in 2018 and 2019. So we have invited Dr. Wayne Squire, who was honored the award from the Innocence Network a few years ago. And we have invited Keith Findley and Kate Jackson from the Wisconsin Innocence Project. And we have also authored books and articles on SBS. And we also try to connect, especially with the medical doctors. We have started an academic study group with doctors, mainly neurosurgeons who were concerned about the situation in Japan. And this was launched in 2019. And also, I have won a research fund from the Ministry of Education with these doctors on the research of the shaken baby or the AHT cases. And we also defend And last but not least, so we tried to challenge the prosecution's case by conducting thorough research of the case, reading the CT scans or the MRI. And we tried to challenge the doctor's diagnosis of abuse. And this cannot be done without the help from the experts. So we work together with experts such as neurosurgeons and forensic pathologists, so medical doctors. And we also ask opinion from experts outside of the country, United States or United Kingdom. And these efforts all led to winning cases. So these are the cases that we have won so far. Since 2018, we have won 10 not guilty decisions in 8 cases. So if you think that the general conviction rate in Japan is 99.9%, which is a quite high number, the cases we have defended, we have won 100%. So this is not to say that that we are good. Well, we are good, but it's to say that the science behind these shaken baby cases were very, very bad indeed. And we also have had charges dropped in more than 13 cases. So we just had another win in the Osaka District Court last Friday. So my last word is that the support from the international innocence community is crucial in winning these cases. So I thank you all.
Thank you so much. You've done amazing work. Those of us who look at the Japanese criminal justice system, I know there's controversy about the conviction rate because prosecutors screen cases, and some people say they only bring cases they know they can win. You have changed the dynamic in this category of cases where through your work, just obtaining one conviction is an amazing victory, but you're really changing the attitude towards these cases of the courts and eventually the prosecutors. And so congratulations on the work that you're doing, and thank you for the presentation.
Thank you.
Our fourth speaker on this panel is Simon Cole from the University of California at Irvine. Simon was gracious enough to come to Asia with us a couple of years ago with Chris to talk about forensic evidence and junk science, a topic that he is one of the leading experts on. But he also has a relatively new role, but now a couple of years old, as the head of the National Registry of Exonerations, which, as I'm sure most of you know, is one of the leading databases in the United States that tracks wrongful convictions and exonerations and provides incredibly important information about each and every case, as well as trends and statistical analysis, and more recently is providing very useful reports on the overall nature of different types of cases. So I won't say any more, but I'll turn it over to Simon.
Thank you, Ira. I want to start by just start on our website, which I always like to do to remind people that you can use it and to show you how to use it. Here's a view of the 2,686 exonerations in the United States since 1989 that we've counted so far. And we have them on a map, and we have various factors about them. So we can filter that for the ones in which forensic science was a contributing factor. And that gives us around 659 cases. So that's around 25% or 1/4 of the exonerations in the United States that forensic science contributed to. If we also filter by DNA, we get a slightly different picture that will work out to closer to 45% of the DNA exonerations that had forensic science contribute to them, which makes a certain amount of sense because these are cases where forensic science was useful in exonerating the person. So it makes some sense that forensic science was more often helpful in getting them convicted in the first place. Beyond the mere prevalence, what else can we say about the contribution of forensic science to exonerations in the United States. And what I'll show you here is, that is the topic of a research project that we're doing at the National Registry of Exonerations. It's a big project and it's ongoing, so it's not done. But what I'll show you here is kind of some, just a couple results from a pilot study. So this is a study of 523 cases to which forensic science, exonerations to which forensic science contributed. So that's that 659 number that I showed you before, but it's as of 2017. So it's all the cases that we had the forensic contribution in 2017 when we started the study. And so, you know, we talk about the contribution of forensic science, but forensic science is kind of a, you know, undifferentiated category. Forensic science encompasses a great variety of disciplines, and there are some ways in which it's not useful to talk about them all as simply one thing. Some disciplines might be more problematic than others. So a very simple, useful thing to know is which disciplines were they? And so we looked at those 523 cases and asked that question, what discipline they are, and those results are here. The number is 664 because, of course, some cases had more than one forensic discipline that contributed to the conviction in that case. And so I won't go into too much detail, but a couple of things to observe about this. First of all, that pretty much every forensic discipline that you can think of is at least represented on this list. It's hard to think of one that is not, perhaps like video and image analysis. I was surprised is not on here, but pretty much everything is. We also found out something we kind of already knew, which was the astonishing kind of overrepresentation of two disciplines in particular, serology and microscopic hair comparison. As Chris mentioned earlier, he mentioned microscopic hair analysis. This has been well known since the Innocence Project started researching this, since Peter's book, Actual Innocence, that singled out serology and hair comparison as the forensic disciplines that played the greatest role in contributing to wrongful convictions. And of course, they're particularly prone to contribute to wrongful convictions in DNA cases, because if there's DNA, that means there's biological evidence. And if there's biological evidence, there was likely to be serology. Hair comparison also came up a lot. So we knew that about DNA exonerations, but it holds true for all exonerations as well. These disciplines continue to just be very high, and even in non-DNA exoneration. So they really stand out as something there. However, we see another big one there that is not at all in DNA cases, drugs, because DNA exonerations are not drug cases at all. So a lot of cases involving drugs, and almost all of these involve what are called presumptive field drug tests, cheap, simple drug tests that are put in police cars and that the police administer on the spot, often at a traffic stop, and is considered a presumptive test that should be confirmed by a laboratory test. But in a lot of the cases that became exonerations, resulted in a guilty plea before that confirmatory laboratory test was actually done. One other thing to observe is there are also some other disciplines that come up a lot in this research. So sexual assault examination, we have a lot of child sexual abuse cases, and sexual assault examinations contributed in those. A lot more pathology and medicine than we saw before. Infant death, which is the shaken baby syndrome cases that Kana was talking about earlier. And of course, Thank you, Ira. And of course, odontology, which Chris mentioned as particularly bad, which isn't bad, maybe that bad in terms of numbers, but that kind of shows how the numbers don't exactly indicate the most problematic disciplines. So the second and last thing I want to show you is kind of try to account for what went wrong in these cases. So we sort of tried to ask ourselves, in all these cases, what generally went wrong? And I would say 4 things. The first is what we call misconduct. The forensic scientists engage in some kind of bad behavior, actually lying, altering results, committing perjury, and so on. That's what we're most familiar with in terms of quote unquote bad forensic science contributing to wrongful convictions. The second thing is misleading. The forensic scientist overstates the value of the evidence, says it's more powerful than it actually is, or in almost as many cases understates the value of evidence that tends to exculpate the defendant. Third is contradicted. Somebody at some point said what the expert said was wrong. Thank you. And sometimes that's another expert, a defense expert, a post-conviction expert. Sometimes it's that same expert. And that comes up in a lot of the medical cases, the shaken baby cases that Kana mentioned. The expert says, I've learned more now about pediatric medicine, and I wouldn't say anymore what I said at the original trial. The most complicated category and the strangest one is undiscriminating. This is evidence in which the discriminating power is so poor that the evidence doesn't really mean very much. And examples of this would include, again, some of the infant death evidence that Kana mentioned, where somebody would say, this could be consistent with shaking, or it also could be consistent with not shaking. So I just wanted to draw attention to that as another category of evidence. And thank you.
Simon, again, thank you also for packing a ton of information into a very short and concise presentation. So thank you for 4 great presentations. One of my takeaways is in this area, forensic evidence and junk science, sharing information is critically important and also productive and valuable. For those of us who study comparative law, we often talk about borrowing. And of course, we see in the presentation some good borrowing and some not so good borrowing. If we go back to how the shaken baby syndrome diagnosis traveled, this bad diagnosis traveled from the United States to Japan. And but we've heard several strategies about how to overcome junk science. And I think there's reason for optimism in the future. Going back to Chris's comments about courts recognizing that unlike precedent in other areas, science is always changing and moving forward. And to the extent courts can start to recognize that forensic science disciplines that were accepted in the past should not necessarily be accepted in the present. That's a huge accomplishment. I want to move to our second panel. We're going to talk about the role of prosecutors. And I think, as Peter mentioned at the outset, prosecutors can giveth and can taketh away. And I think that's going to be the theme of this panel, situations where prosecutorial misconduct contributed to wrongful convictions, but the work of prosecutors to re-examine questionable convictions, has also led to exoneration. Let me first introduce lawyer Jiada Huang from China. Jiada was a visiting scholar with us a year ago, and I would say of all the visiting scholars we've had at NYU, he's one of the people who took the greatest advantage of being at NYU. He was constantly learning and studying and going to class, but also giving back to our institute and sharing his own experience and knowledge and analysis of the problem of wrongful convictions in China. And since he's returned to China, I know he's been part of a network of lawyers who both work on wrongful conviction cases, seeking the exoneration of the innocent, and then also publish the work they do on a joint website called Exonerating the Innocent. So Jada, I will turn it over to you. We'd love to hear from you especially about any new developments regarding the role of prosecutors in wrongful convictions and exonerations in China.
Yeah, hello everyone, I'm Jia Huang, a criminal lawyer from China. And in the past, I have shared some of our Chinese Innocence Project experience with some of you. And today I'd like to talk about the provision of examining appeal case in different places by people's procuratorate. This mechanism is good for such situation, like the compliance application is still delayed after the acceptance, that the review process encounters greater resistance in handling the case, which may affect the fair handling of the case, like due to the statutory reasons such as recusal and like other situations that are not suitable for the provincial people's procuratorate in the jurisdiction. And in the past, I mean, before 2017, China, the notice of the Supreme People's Procuratorate on relevant issue concerning the handling of a prisoner criminal appeal case is mainly about a prison procuratorate review of prisoners who appeal in the prison. And 2014 provisions on the re-examination of a criminal petition case by the Supreme People's Procuratorate in the Article 13(5), it says the lower level People's Procuratorate shall handle criminal appeal case assigned by the higher level People's Procuratorate in accordance with the law. And the typical case are like the Zhejiang province Zhanghui Zhanggaoping case. They were serving sentence in Xinjiang prison, and the Xinjiang procurator Zhang Biao has played a very important role in the case. And the second case is the Chen Man case. It happened in Hainan province, and the Supreme People's Procuratorate assigned Zhejiang province to review this case. And in the history of the provision in 2015 on the Central Political and Legal Committee demanded to explore ways to establish the mechanism of examining appeal case in different places. And then in 2015 National Conference of the Chief Procurator, in 2016, the 14th Procuratorial Work Conference, those two conferences both bring this system up. And then the Criminal Compliance Office of the Supreme People's Procuratorate drafted out the first version of this provision, and then solicited opinions widely. From 2015 to 2017, according to the spirit of the Central Political and Legal Committee and the Supreme People's Procuratorate on this mechanism, some local procuratorial organs had made useful explorations, and some local procuratorial organs have also formulated normative documents on this system. And finally, the provisions as adopted at the 70th meeting of the 2012 Procuratorial Committee of the Supreme People's Procuratorate on October 10, 2017. In the provision, two types of criminal appeals case are applicable. Like the first one is dissatisfaction with the procurator's decision to determine. And the second tab is dissatisfaction with the court's effective criminal judgment or ruling. And there are three ways to initiate a different place review. The first is the Supreme People's Procuratorate found that the criminal appeal case under the jurisdiction of the provincial courts may be wrong and matches one of the 5 situations. And the second is if the provincial court believes that the criminal complaint case needs to be reviewed in another place, it can apply to the Supreme Procuratorate for a remote, different place review. And third is the complaint can apply to the provincial court or the Supreme Procuratorate for a different place review. Of course, for the first and the second situation, the compliance consent should be obtained. And in the implementation, actually, is not really the case, or we could say is a bit more complicated than the provision. In the past 3 years, although many complainants or defense lawyers have been full of expectation for this regulation, for this provision. In fact, we had not seen such case, nor have we seen any follow-up official reports, although there may be some case in which the program is initiated and rehabilitated. The implementation of the different place review requires the publication of several typical cases. It also requires the Supreme People's Procuratorate to introduce how the system is being implemented in the report of the National People's Congress or in other forms. Thank you all.
Jada, thank you for introducing that system. It's kind of amazing that China has adopted the idea that if one prosecutor's office perhaps made a mistake, that it would invite a different prosecutor's office to review the case. I think the experience in the United States, while it's not exclusive this way, it's often when a new prosecutor is elected or appointed and they review the work of a prior prosecutor, that wrongful convictions are uncovered. There is an inherent conflict when a prosecutor's office is required to look at their own cases. So the theory makes sense, but I guess we'll have to wait to see if more cases actually use this process. And I would be interested in hearing in the future. The other issue in China, which has a unitary judicial system, whether just going from one prosecutor's office to another is enough to eliminate the kind of inherent bias that prosecutors may have in favor of upholding the work of their colleagues. But thank you for introducing a really fascinating innovation in the Chinese system. Next, we're going to go to the Taiwan Innocence Project and to Ms. Ke Yunqing. I think all of you know, or you heard in the introduction about the work of the Taiwan Innocence Project. It's been incredibly impressive, both their track record in obtaining exonerations of wrongly convicted persons, but also in their work publicizing what they do, providing analysis and teaching.
Yeah.
And
Okay.
I think there also been some interesting developments in Taiwan with respect to the role of prosecutors. And so we look forward to hearing your presentation.
Awesome.
I'm going to turn it over to you.
Thank you, everyone. My name is Ke Yunqing from Taiwan Innocence Project, and it's an honor for us to join in this panel and to share some of our experiences, especially on the role of prosecution in the innocence movement here in Taiwan. So Taiwan Innocence Project was established in 2012, and in the past 8 years, we have already 10 exonerations. And this year, and 4 cases that are now in the process of retrial. And one of the 2 new exonerations we have in 2020 is Mr. Xie Zhihong, who was exonerated in May 15 this year after spending almost 19 years behind bars for a double homicide he did not commit. That's the longest time lost for a death row exoneree in Taiwan. We will get back to Xie Zhihong's case because his exoneration was much accelerated prosecution in Taiwan. Xie Zhihong was not the only case when a prosecutor joined and helped. In fact, based on our experiences in the past few years, some of the prosecutors in Taiwan became more friendly toward the innocence movement, but it was not much so before 2015. So when Taiwan Innocence Project had just started in 2012, we learned a lot from the innocence movement in the United States, including this book. It's actually, Convicting the Innocent by Professor Brendan Gary. And we have translated it into Mandarin in 2014. And we also learned the idea of evidence for disclosure. So in 2016, we invited Prosecutor Ina Chandler to be the keynote speaker of our annual conference as a way to further understand how this works in Texas, and also as a way to persuade our judicial system to consider this new kind of unit inside the prosecution. In the same year, one of our board member, Professor Jin Menghua, also published one paper trying to introduce the ideas of CIU into Taiwan. And those efforts seem to work somehow, especially manifested in the following three wrongful convicted cases: Lü Jianming, Zheng Xingze, and Xie Zhihong. Lü Jianming was the first case when a prosecutor filed a motion for retrial on behalf of the convicted and asked for a DNA retesting. And that case, and he had successfully achieved exoneration. And that was in 2015. And then in the next year, in 2016, a prosecutor in Taichung reinvestigated the case of Zheng Xingze, who was sentenced to death for murdering a police officer in 2002. And she unprecedentedly filed a motion for retrial on behalf of a death row inmate. 2 months after she filed the motion, the retrial was granted, and Zheng Xingze was released, as the photo shows. He then was fully exonerated in October 2017, becoming the sixth death row exoneree in Taiwan. When we thought what happened in Zheng Xingze's case was just a deviant case, in the next year, in September 2018, another prosecutor in Tainan also filed a motion for retrial on behalf of Xie Zhihong. At that time, Taiwan Innocence Project has spent almost 6 years on his case, but all our attempts failed. But 7 months after the prosecution stepped in, Xie Zhihong's retrial was granted, and he was released in March 2019 and was fully exonerated in May this year. So now we already know that when prosecutors are willing to help, the chances of an exoneration are much better. But why and how the prosecutors in Taiwan would be willing to join the innocence work? We once thought that maybe it's because that we have tried to institutionalize the ideas of CIU in our judicial system. For example, the Supreme Prosecution Office have set up a team to review controversial death penalty cases in 2016. And in 2017, the Ministry of Justice have set up our version of CIU in the prosecutor's office to review convicted cases. But after years of running, those two systems didn't really seem to work. So now we think that one of the most critical factors that push the prosecutors in Taiwan to take part in the innocence work is because that has always been their jobs. So in our Code of Criminal Procedural Law, there are 2 related articles suggesting that the prosecutors are the public officers, and their duty is to give equal attention to circumstances, both favorable and unfavorable to an accused. And they clearly own the right to file a retrial for the interest of the defendant. Under this kind of unique precondition, we came to realize that if we can present a compelling case of innocence to the prosecution, and that if we can take a more cooperative approach to them, some, not all, but some of the prosecutors will be willing to work with us in order to get their job done. So as the Attorney General said when he attended our annual conference in 2018, prosecutors shall do their jobs while understanding how devastating a wrongful conviction can be. I think that what he said kind of sums up the general mindset of our prosecutors in Taiwan, and also that explains why some of the prosecutors are not that reluctant to Innocence work. Of course, since that is more like an work ethic, and since the current institutionalized units for reviewing cases doesn't really work well, sometimes it depends on which prosecutors we encounter in each case, and sometimes that means luck. And I don't think we really want our exonerations depend on luck. So I think we still have some way to go. Okay, thank you. Please let us know if you have any questions in the QA section. Thank you.
Yunqing, thank you very much for that presentation. Your work with prosecutors is really interesting, and because the work getting prosecutors to join you is something that's not necessarily transparent to the public. I think it's an area where different innocence projects and innocence lawyers could benefit from sharing some of their strategies for how to win prosecutors over to your side. I noticed in the list of participants tonight, we have at least one member of a conviction integrity unit, the head of the unit in the Bronx, Risa Gerson, who's participated in many of our programs and been extremely helpful to us and helping us understand how conviction integrity units work. And I hope Risa will have a chance to comment during the Q&A period on this topic. Our next speaker, Sharon Beckman from Boston College, the director of the Innocence Project at Boston College, has a very specific case, a recent case, where I think she can talk a little bit about both the positives and the negatives of prosecutors. And I think her case, we heard about it. It's an amazing case, and we're really lucky to have Sharon share her experience with us on this panel. So Sharon, I'll turn it over to you now.
Okay, thank you, Ira, and thank you to the US Asia Institute. I'm so grateful to be part of this gathering and part of this conversation. Well, the case that Ira mentions is the case of our client, Frances Choi. It is gut-wrenchingly sad, like all wrongful convictions, and also a very disturbingly vivid example of systemic racism in the American criminal legal system. I hope my story ends in the direction of optimism, both for Frances and for systemic reform in Massachusetts. I'm not going to talk about our program, I'm following the directions, but I do want to say something, especially to our partners and participants in Asia, that as Meredith Kennedy said, innocence organizations come in all different shapes and forms. And there is a special value to innocence organizations that are housed within universities, because we're able to draw on all of the resources and departments of the university. And in Frances Choi's case, for example, we received assistance from the psychology faculty and a graduate student from the School of Social Work. The other thing about law school and university-based programs is that our students become agents of change. So our students become lawyers, some of whom become prosecutors and judges and legislators, and they're well equipped to be the type of change that we're talking about here. I want to say a few words about my amazing client, Frances Choi, who our clinic had the great privilege of representing along with her appointed attorney, Boston solo practitioner, John Barter. He represented her since 2011 and invited our program to join him as co-counsel in 2017. Frances is a first-generation Chinese American. Her parents were Chinese immigrants from Hong Kong and Vietnam. She has a very impressive resume. She has a degree in sociology, magna cum laude from Boston University. She is a cosmetologist. She is a sous chef. And you see her here pictured with Valentine, one of the therapy dogs that she raised for American service veterans. What's really remarkable about these accomplishments is that Frances achieved them while she was wrongly incarcerated for half her life for a crime she didn't commit. She was imprisoned from age 17 to age 34. She is the only Asian American woman on the National Registry of Exonerations, and the first Asian American exonerated in Massachusetts. I emphasize these points only to say that one of the things we learned working on Frances's case is that the wrongful prosecution and convictions of Asian Americans is very unexamined in the United States. Frances was only 17 when she was rescued from a fire in her family home. Tragically, her parents, Ann and Jimmy Choi, died as a result of injuries they sustained in the fire. From the moment she was receiving treatment in her hospital bed, she was treated by law enforcement officers as a suspect rather than as a victim of this horrible crime. She was interrogated, arrested, and imprisoned, all in the same day that she became orphaned and homeless. She endured 3 trials and was eventually convicted of arson and 2 counts of first-degree murder. Though she was only 17, she received the then mandatory sentence of life without possibility of parole. The causes of Frances's wrongful conviction are many, and the time today does not permit to go through all of them, but I list them here because it's typical of many wrongful convictions cases for which there is not just one cause, but many intersecting and coordinating causes. Today, I'm going to focus on the contribution of the prosecutors to her wrongful conviction. What I'm going to mention here are the types of prosecutorial conduct that contributed to Frances's wrongful conviction based on the findings and holdings of the motion judge who vacated her convictions in September. That judge is the same judge who presided over the trial where she was convicted. Some of these things are the typical things we see in wrongful convictions cases, and some of them are more extreme misconduct. In this case, the prosecutors withheld exculpatory evidence of Frances's innocence and evidence that pointed to the guilt of the actual perpetrator. They made misleading closing arguments to the jury and false representations to the court. More shockingly, they knowingly induced and presented false testimony by law enforcement. And one of the things we found in the open file discovery, which I'll talk about in a moment, is that the night before his testimony in Frances's 3rd trial, one of the trial prosecutors emailed the detective a script for his testimony, question, answer, including an answer that he had admitted under oath in the 1st trial was not correct. She was present for that testimony, and she nevertheless induced the false testimony again in the 3rd trial. But now what I want to focus on is the very disturbing example of intentional anti-Asian racial bias against Frances, her family, and all Asian Americans. The time does not permit me to show you all of these emails, but in post-conviction discovery, we discovered that during the time they prosecuted Frances for 3 trials, the trial prosecutors exchanged with each other electronic mails with images and words mocking and demeaning Frances and her family and Asian Americans in general. Some of the slides, some of the emails included what the trial prosecutors considered to be jokes, making fun of Asian Americans for whom English was not their first language. Some of the slides were just strangely racist, like a photograph of a little girl wearing a Ku Klux Klan outfit. The slide I'm going to focus on here is an image the trial prosecutors emailed back and forth with each other, depicting, this was an image downloaded from the internet, originally with a photo of a Girl Scout. And behind her is the suggestion that she has burned down a house because the people who live there wouldn't buy a box of Girl Scout cookies. This is disturbing in and of itself, but it became the prosecutor's closing argument, the same theory, that Frances was the kind of emotionless, narcissistic, controlling person, only concerned about herself and her stuff, who would burn her parents to death so that she could have a better social life when she went to college the next year. Students in the clinic working closely with the social work student in the psychology department did social science research and discovered that this actually is a commonly held stereotype that white Americans hold about Asians, that they are lacking in interpersonal warmth and kindness, cunning, sly, and selfish, and that they will stop at nothing to achieve their ends. So the same racist stereotype in the prosecutor's emails that became their closing argument was a widely held stereotype that would resonate with the all-white jury. Another set of images the trial prosecutors sent back and forth to each other is the image of the absent immunized accuser. Francis was convicted based on the testimony of a witness who the jury never saw. Instead, the prosecutors did a role play of his testimony based on a transcript of a prior proceeding. The image they emailed back and forth to each other is a character from a 1984 movie about high school students in America called 16 Candles. The character, Long Duck Dung, is widely perceived to be the most damaging stereotype of Asian men in popular American film. The character is both oversexed and emasculated. He wants to get the girl and he is manipulated by the girl. The prosecutors throughout the time of the three trials emailed images back and forth to each other of this character saying they couldn't get enough of him. How this fit with the theory of the case was that this individual, the evidence was that he had written a note to himself on his own stationery, step by step, how to burn down the house, but accused that Francis told him to do that. So their theory of the case was that she manipulated him. And in fact, some of their emails suggested jokingly that the two of them were engaged in incest. Most disturbingly, perhaps, is this image that the trial prosecutors exchanged with each other about the time and date of an interlocutory appeal in the case between two of the trials in the Massachusetts Supreme Court. And you see here one of the trial prosecutors emailing to the other, "I'll show up tomorrow wearing a xiangsam and we'll be the one doing origami in the back of the courtroom." Francis's mother had multiple siblings who lived in the area, and throughout Francis's three trials, her extended family came to the courtroom and sat in the back of the courtroom in support of her. So one understanding of this email that it is literally mocking and demeaning the survivors of the victims. We made an argument based on these emails that I don't think has previously been made in any American court, that the prosecutor's racial bias constituted structural constitutional error requiring automatic reversal of her convictions, because a person is entitled under the Constitution to be tried by a prosecutor that is not biased against them based on their race. The motion judge did not reach the constitutional claim, but instead made a specific finding that justice may not have been done in part because of the racial bias of the prosecutors. A new team of prosecutors joined the prosecution office. It was the same elected district attorney at this entire time, but a new team of prosecutors came in, and they, in the summer of 2019, provided us with open file discovery where we went through all of the materials in their file. We filed our motion for post-conviction relief in January, and then a motion for Francis's release in March. Literally nothing happened until April 13th, when the prosecution filed its own filing agreeing to the stay of sentence, and the same day the court granted Francis's release. And then you can see in September, the prosecution filed its own response supporting the motion for post-conviction relief, adding additional grounds. A week later, the court granted the motion, and a week after that, the prosecution no prost. So things moved very quickly once the prosecution decided justice had not been done and took affirmative steps. The last thing I want to say is that this prosecution office, the Boston College Innocence Program, and many other stakeholders have been involved since 2019 in a statewide conviction integrity working group with the goal of recommending best practices for conviction integrity units in all Massachusetts prosecution offices. And we're working on consensus on a document we hope will be produced in the spring of 2021. The last thing I just want to say is what prosecution integrity means. All of the Innocence Network organizations know this, that these are 3 clients of the Boston College Innocence Program exonerated or released within the past 2 months by agreement of the prosecution. And they are among 6 exonerees in Massachusetts whose exonerations were agreed to by 4 separate district attorneys' offices. So I'm hoping that this is suggesting a culture shift within our state as across our country. Thank you.
Thank you, Sharon. I was loath to interrupt you because the case is so interesting, and congratulations on that victory, and appreciate your sharing the details with us. Our next and the final panelist is Sam Gross, who really needs no introduction to the community of people working on exoneration cases. He is the co-founder of the National Registry of Exonerations and continues to work as a senior editor at the registry, and is recently one of the authors of a incredible report about the role of prosecutorial misconduct in wrongful convictions. So I'll turn things over to Sam. I also, before I do that, I just want to mention again, I think there's some folks in the audience who also have experience with either as prosecutors or in conviction integrity units, and I would encourage them to also comment or pose any questions they would like during the next session. So Sam, let me just turn it over to you now. Thanks.
Thank you, and it's a pleasure to be here. I'm not going to talk in any detail about the report that you mentioned on government misconduct and false convictions and wrongful convictions. The general findings that we had in a sentence are that misconduct by government officials contributed to 54% of the first 2,400 exonerations in the National Registry of Exonerations. 30% of the cases include misconduct by prosecutors, 34% by police officers, and smaller numbers by forensic analysts and child welfare workers. The most common type of misconduct that we identified was concealing exculpatory evidence, which occurred in about 40-some% of all of the cases. What I'm going to do instead is talk about a few cases, or in one case, groups of cases that may be well known to some of you, and try to very quickly offer some explanations for why this type of misconduct occurred, focusing on the role of prosecutors. The first one is the case of Michael Morton in Texas. What happened there is in 1987, the prosecutor in this case, Ken Anderson, who took him to trial and got a murder conviction for his supposed murder of his wife, Christine. In the process, he concealed the following items of evidence from the court and from the defense and from the jury. That a suspicious stranger was seen hanging around the Morton's house a couple of days before the murder. That while Morton was in custody after he was arrested, someone else attempted to use a credit card belonging to his wife, and somebody, probably the same person, cashed a check, both of which were taken from her purse. Obviously, that would not have been Morton himself. And that his 3-year-old son told his grandmother, that is to say, the mother of the victim of Morton's wife, that, quote, a monster, end quote, had killed his mother, and that when that happened, Daddy was not there. All of that was not known to anybody outside the prosecution and the police, and Morton was convicted. He was sentenced to life in prison. In 2011, 24 years later, DNA testing on a bandana that had been found near the scene identified the real killer. The district attorney's office had resisted DNA testing on that bandana successfully for perhaps 15 years. In the meantime, the real killer had killed another woman under similar circumstances within a year or two after killing Christina Morton. So this is a horrific case. And Anderson, very atypically, lost his job. By then he was a judge and was disbarred. He spent 3 days in jail as a result of this. But that's not what I want to talk about. The question is, and I think the answer is not very complicated, why did he do it? Why did he conceal this evidence of innocence in the case? And I think the first thing that is probably true, although we don't know, is that he believed that Morton was guilty. That seems crazy, but he had a theory of why Morton did it, and he probably believed it. I don't think it matters. He may not have, because I think the main reason why he did it, and this is guesswork, but it makes a lot of sense, is that he did it because that was his routine practice. That concealing exculpatory evidence in a case that might go to trial, and probably in many other cases, was something that he just regularly did. And usually it didn't matter. The defendant pled guilty. The defendants were usually guilty. If they weren't guilty, nobody ever found out. And it just went on. Very likely the defense bar in the county wasn't strong enough and hardworking enough to challenge him on this successfully, and it kept on going until he ran into this case, which was a tragedy for everybody and ultimately destroyed his life as well. There's some evidence of that, because after the exoneration in Morton's case, because there was a systematic review of other cases in the county, another case in which a deputy of his concealed critical exculpatory evidence came to light, and another defendant was exonerated, which means that it could well have been much more common. There could be other innocent defendants in that county who were victims of this practice that we don't know about. Switch to Chicago. Perhaps the most notorious and horrifying set of exonerations in the United States, large set, are those of defendants who were tortured in Chicago in the 80s and and some in the 70s into the mid 80s, under the command by police officers acting under the command of a police commander named John Burge. I'll give you a tiny little excerpt. The first documented case that we know about in which he used torture occurred in 1973. It was an investigation of a murder. The defendant, as were essentially all of the cases that we know about, the defendant was an African-American. He would not confess. Burge came into the office, picked up alligator clips, those are electrical clips, and said, and you'll pardon, not my language, his language, he said, "Nigger, you're going to tell me what I want to know." He attached the clips to, I believe, the defendant's genitals, and started turning a crank that generated a current that produced electric shock torture that went on. This was one of dozens of cases of this sort. When they ultimately came apart starting in 1991, it led to a creation of a torture commission. 32 defendants were compensated for the torture they received. At least a dozen or so were exonerated. God knows how many more were tortured. The city spent a huge amount of money on this. The lives that were destroyed are beyond reckoning. But that's not what I want to talk about. I have very little time to go, but I will just summarize it very quickly. The real evildoer here was not Burge. The question that jumps out immediately is, how did this go on for 15 years in a city where it has to be the case that not only dozens, but probably hundreds of people knew about it? And we know this. We know that they knew it at the highest level, because in 1982, the director of the medical center at the Cook County Jail wrote to the chief of police and told him that a prisoner there had been injured, and that the injuries occurred after he was taken into custody. And the chief of police wrote to Richard Daley, who was then the state's attorney, that is to say the chief prosecutor, and later the mayor of Chicago, and said, "I will forbear from taking any steps until I hear from you or one of your assistants," because the prosecutor was handling the prosecution in that case, and Daley did nothing. 20 some years later, when it all came out and Daley was asked to apologize, he joked about it. He said, "Okay, I apologize to everybody for whatever happened in the city of Chicago. I don't know if I did anything, but I'll just apologize. But," quote, "I wasn't the mayor at the time. I was not the chief of police. I did not promote Burge," which of course is deeply hypocritical, because he used evidence produced by Burge and his officers regularly, and he could have stopped it by refusing to use that evidence, or better yet, he could have prosecuted the torturers, which is what his duty, which was what his duty was, but he never did. This isn't the only case of these sorts. I'll refer to another one, but not really talk about it. The cases of forensic fraud, the worst type of forensic bad forensic evidence of the sort that was talked about before, where they occur. Typically, if it's more than one case, are cases where the prosecutors know that they're dealing with a witness who can't be trusted and go ahead and continue to use them because it makes their life easier, because they get the convictions they want, and because they don't answer to anybody. That's it.
Okay, thank you, Sam. It was a very moving presentation. We're going to move to Q&A in a minute. I just want to follow up with one thing, and you'll correct me if I'm wrong. I think that after the scandals in Chicago, a young Illinois state legislator introduced a bill that was eventually passed, requiring the videotaping of police interrogations. And if I'm not mistaken, that legislator's name was Barack Obama.
He played a role in it. He certainly played a role in it. He writes about it in his biography now, in his recent biography. That's correct.
Yes, I want to turn it back to Catherine and to moderate the Q&A period.
Okay, thank you. Thank you, Ira. This was all terrific. I really want to thank all of the speakers who, as Ira had said at the beginning, could definitely have just carried the whole evening for us, each of you individually. There's a question that I think is a good place to start because it fits nicely with where we just landed with the last two presentations talking about official misconduct and prosecutorial misconduct. And it's asking about the role of institutional culture and how to push on institutional culture to solve these problems, to minimize or reduce the occurrence of official misconduct. And I would add to that maybe, because often when you're trying to address a problem like this, you need to push it multiple ways through multiple channels about the role of the public and the role of the media to be active in oversight and to be even given more access than they currently have to be able to exercise oversight. So I'd be interested if Dr. Gross, you and also maybe our colleague from the Taiwan Innocence Project could talk a little bit about which buttons you think would most effectively be pushed to try to address the misconduct and also to reward and to expand on the good conduct that we're seeing from the Taiwanese prosecutors in the last few cases. How can that be magnified and encouraged, the good conduct, and how can the misconduct be discouraged?
I'm not sure I can answer the question you asked, or maybe a piece of it, but I think what it takes to change the institutional cultures that create and that perpetuate misconduct is really the big question. The conviction integrity units and other reforms by progressive prosecutors in the United States are a good example of how that can be done. My impression from what we were able to learn from in the report we put together is that in the United States, at least, this will be difficult, but not beyond reach for prosecutors. Perhaps a bit easier for forensic science if prosecutors support it and if there's sufficient funding, and extremely difficult in some police departments, because police departments in the United States can be very insular, and because unlike prosecutors' offices and unlike forensic science, the people who work in police departments don't have colleagues in training that overlaps with people who do other types of work. They only do forensic science. They don't work on other types of scientific work. They don't have colleagues who went to other types of legal practice the way lawyers do. But it's not an easy question to answer.
So Yunjing, would you like to take up the question from perhaps from the positive side, which is you were telling us a story about how prosecutors in Taiwan have actually taken to heart their legal responsibility to produce exculpatory evidence as well as the inculpatory evidence, and to be completely fair in their prosecutions, and that this is why you believe that they acted as they did in those two cases that you were telling us about, where they were the key factors in the exoneration. They got the process going finally after years of stalling. How was there something unique about those prosecutors, the individuals involved, or the offices they worked in? Was there an effort that had been going on to train them to take this responsibility to heart? Or do you think it actually is always been there, just perhaps was lying dormant? And it, is there an explanation, and how can it be magnified? And how do you plan with your project to magnify that good example?
The question was like for several different parts, and if the question is is pushing for prosecutor accountability can increase the possibility of prosecutors to join the innocence work, I think that depends, because if you push that too hard, sometimes you'll get some pushback by the community, because it's actually sometimes it sounds like you're correcting their mistakes. So I think we can only encourage the prosecutors to join us in a more like cooperative way, and not that just, so as one of my slides said, the approach should move from confrontation to cooperation. So that was kind of a strategy for us to try to work with the prosecutors, not just to correct their mistakes, but to ask them to join us to work together. So that was the first part. And the second one is, I think that is kind of a chance that, because of the Attorney General really supports the idea of prosecutors joining innocence work. And I think that so that means the leadership of the prosecution office means a lot, and that they can really affect how individual prosecutor decide what they are going to do with each cases or each claims of the innocence organizations that we brought to them. And then the third part is that I think it's not really like the innocence organization trying to teach them something. It's not like that. The frequent situation is that we brought our compelling scientific evidence that can suggesting the innocence of our clients. And usually that science is what they really buy into. It's not how we talk to them. It's not like the belief they are trying to believe us. It's not, but if we can bring compelling scientific evidence that strongly suggested that our clients are innocent and it's their job to right the wrongs, they will accept that. So I think they have different ways to motivate prosecutors to join in. And actually the last part, maybe echoing what Catherine had mentioned before, is the media's or the support of the public. Because if the public is generally phrasing, prosecutors joining innocence work and giving fair trial on both sides, I think each of the prosecutors will be more willing to join this area of fight. Okay, thank you.
To corroborate that, much of the progress we've made in Massachusetts, both with respect to forensic evidence and with respect to prosecutorial misconduct or best practices, has been the result of collaboration between the public defender, the Innocence Network organizations, and DA's offices. And at this point, it's not just the so-called progressive DAs, but these working groups are including a broad spectrum of DAs with some positive results. I just also want to add, because Professor Hellman posted a question about bar discipline, and I did want to say that we have an interesting case pending now in Massachusetts. We had a major drug lab scandal, and Nina Morrison of the Innocence Project and Dan Medwed, a professor at Northeastern Law School, filed a bar complaint against the assistant attorney generals who withheld the exculpatory evidence. It's pending now in a bar hearing before the Boston Board of Bar Overseers. So it'll be really interesting to see if any action is taken in that case.
I wanted to maybe address this to Chris, but also anyone else on the panel. You know, we're about to have a new president and a new presidential administration. In the Obama administration, the advocacy efforts for eliminating junk science through the administration made a great deal of progress, culminating in the PCAST report that you all worked on and contributed. And that report was then trashed by the next administration. I'm just wondering, with the Biden administration, this is now the topic on everybody's mind. You were able to still make a lot of progress in the field through litigation, but I'm wondering what your thinking is and what your strategy is with a more receptive audience, hopefully in the Biden administration, to further the cause of eliminating unverified forensic sciences from the criminal justice system.
Well, to be fair to, well, not to be fair, to be clear, it was Loretta Lynch, who was Obama's AG, who trashed the PCAST report and said, thank you, no thank you. And because, you know, so there's always that, you know, I mean, and there's always great resistance on the part of prosecutors, no matter what. The status quo serves their ends typically. So at the federal level, the progress that was made with the National Forensic Science Commission that Peter Neufeld sat on, amongst many other luminaries in our field and scientists, it was really important in terms of, you know, to talk about the progress that was made during that. It was so incremental and so tiny in many ways, but so important at the same time. And it just things about like report writing, right? You know, this idea that you would actually lay out and present your bench notes and to have a complete forecast of what your testimony was going to be was something you just don't even get in forensic science. And it's just a core scientific concept that you would get in any civil litigation would be automatic. And so this idea that some of the low-hanging fruit that's available in forensics was started to make progress at the federal level. I think that type of progress can be made again with the Biden administration. There will be receptivity to that because some of the asks are so low. You know, I mean, we're just talking about transparency issues that are the norm in any kind of scientific endeavor. So I think that we're going to try, but I think that a lot of advocates around the United States, certainly me as a litigator primarily, is that we're looking for reform at the state level. Because at the federal level and the federal courts, you know, I mean, you don't get, you know, actually the federal courts are good on science, but that's not where the wrongful convictions are happening. The wrongful convictions are happening in state courts, and the junk science is getting in state courts. So I think what we're going to try to do is take a lot of the federal progress that is made as essentially a trickle down, right? And that the policy and some of the better decisions around forensics are going to come from federal courts and from federal agencies. And then we're really going to try and implement that in state courts to really create change.
Great. I mean, just a quick follow-up. I think that the work that the PCAST report did, the commission did, and the commission before it has resonated overseas as well. And so that's part of the reason I wanted to ask the question.
I'll just say one other thing about that, and as it relates to the PCAST report, because, you know, as everybody said, you could go, you know, spend hours talking about these issues. But the citation that I read to the National Academy of Sciences report in 2009, as it being an abuse of discretion for a trial judge not to consider that, is unheard of 5 years ago. You know, I mean, when I first started at the Innocence Project, there had never been a single positive citation to the NAS report in any criminal litigation at all. The first case that I'm aware of was a case that we worked on in Texas, Stephen Chaney's case, an Bite Mark case. Now you're starting to see that. So progress in this area, I expect the PCAST report will be similar. Some of the wording in the PCAST report was too sharp, and I think it ended up, it being taken more personally even than the NIS report to a lot of people. But I think in the end, progress like that is going to be made. It's just that we all, end up like going back to MLK's quote about the arc of justice, because it's very, very long, it's, and, here we are, and we're finally, finally starting to see some of the progress that promised in 2009 when the National Academy of Sciences first issued this thunderbolt, that the emperor has no clothes. And, so, there's reason for optimism, but we're all going to be, I'll probably have full gray hair by the time we come back and eliminated junk science.
Well, thank you. It's with great regret that I say we have to wrap up the discussion because it is quite interesting. I'm personally grateful that each of you from each jurisdiction has given us some good news because I think we're all pretty hungry for it in these days. And that has been terrific to hear. And so I'm going to give, as has become our habit recently, I'm going to give the last word to our founder and faculty director emeritus, Jerry Cohen, who has been with us and from up in Massachusetts, and is going to give us a few words of benediction to send us off.
I just want to say that this was a very exciting program. When we started the U.S. Asia Law Institute about 14, 15 years ago, I don't remember, we didn't have anything like this going. And to see the way that through the direction of Ira and now Catherine, and I haven't seen her tonight, but Amy Gao was working very hard, I know, and others responsible for this program. It's a terrific achievement. It's a great achievement that we've managed to latch on to the Innocence movement in the United States, that we've extended our interest and cooperation to various important countries of East Asia. We're doing this in a comparative joint way. We're exchanging experiences, learning more, and we're working together with people beyond the law in various fields of physical science and social science. So this is a tremendous project. And if our institute is going to stand for anything, it's got to stand for the prevention of wrongful convictions and the curing of wrongful convictions. So I'm proud of what we've done tonight. And I only regret 2 hours is much too short. And perhaps we can have more extensive programs in a more systematic way, having experimented with this. But congratulations to the speakers and to the organizers. I've had a great time.
And to our participants, thank you for being with us this evening. We hope to do something like this again, not too far from now.